Thank you for joining us for the second part of Special Needs Trust and Planning. We appreciate Mac Bailey's time and his presentation on the ABCs of SNTs, and we will now move into the ethical considerations when using special needs trusts. I'm Teresa Law, the Public Relations Marketer with VistaPoint Special Needs Trust and Resource Center in Tennessee. I will be joined later by Darlene Kemp, our Executive Director at VistaPoint. To give you a little background, VistaPoint Special Needs Trust and Resource Center was founded in the year 2000 to provide education, advocacy, provide referrals, and services related to special needs trust. The company serves as the professional trustee for the Tennessee Pooled Trust. Darlene brings a wealth of education and training to her position. She holds a Master's of Public Health with a concentration in gerontology from the University of Tennessee. Go Vols! She also has a Master's in Business. She's an overachiever, folks, with a concentration in healthcare management from the University of Phoenix. Her bachelor's degree in Family and Consumer Service was also obtained from the University of Tennessee. I joined VistaPoint Special Needs Trust in the year 2017, bringing over 20 years of experience in the healthcare arena. I spent time while performing hands-on nursing in the hospital, skilled nursing facilities, and home health, as well as management in non-medical and the assisted living arenas. I found that helping those dealing with the uncertainty of available services and payer resources held back so many individuals, especially those living with disabilities. I received my LPN training at Nashville Memorial Hospital in Madison, Tennessee. Our agenda for this session will cover an overview of Special Needs Trust, definition and usage of each of the trusts available, ethical considerations, and then our conclusion. We hope that you will write down any questions you may have during this session and remain with us for the Q&A at the conclusion. Special Needs Trust, as we know them today, became a part of our legal system with the enactment of the OBRA Act of 1993. Special Needs Trust is a legal arrangement that lets a physically or mentally ill person or someone chronically disabled have access to funding without potentially losing the benefits provided by our public assistance programs. The trust allows for the additional financial support of an individual with special needs without risking bumping them out of contention for disability benefits. This becomes especially important as the cost of things increase, but not necessarily the checks that we often receive through our government benefits. Public assistance programs set up for people with special needs are pre-dedicated on certain income, asset restrictions. So we put money into a trust that doesn't count toward the purpose of qualifying for public assistance. These trusts are protected, and the money that's put into them are not considered ready assets when you're applying for government benefits. A special needs trust covers the percentage of a person's financial needs that are not covered by public assistance payments. The assets held in the trust, as we said, do not count as readily available cash, so it doesn't hinder you from qualifying for public assistance. The one thing that we don't need them used for is for certain food or shelter expenditures. Proceeds from a trust can commonly be used for medical expenses, payments for caregivers, transportation costs, other permitted expenses that we'll go over on toward the middle of our presentation. A pool trust is the first of 3 trusts that we will discuss. A pool trust must be administered by a nonprofit organization. Although each beneficiary has his or her separate account, the assets in the trust are combined. They're a combination of several investments from many families or beneficiaries. People often look at me with that, what? Look, and I say, well, let's just think of a swimming pool. Each person is in the swimming pool, but you're on your own floaty, and that's where your money is. Your own money is held in your own separate account, but can be invested together so that you get a higher return on your investment. A lot of times you may not have the minimum requirement for that investment, but pooling the funds together allows you to do just that. A pool trust, keep in mind, is a legal contract under federal law. Certain parties must be recognized and established in order for the trust to be administered properly. The people that we need to be looking at, we must have the beneficiary. That is the person that lives with a physical, mental, or intellectual disability. This disability must be considered permanent in nature. In other words, something that will not improve and go away over time. A lot of times we only think of a disability as being one that we can see, but you've also got to consider that your physical disabilities can be someone that was recently diagnosed with lupus, knowing that they will lose the ability to work and to have the income that they have. A trust can be established early to be able to look at that. We often have people ask and go, my son has autism, but he's doing just fine right now. But autism is a diagnosis that is approved for a special needs trust, and families should consider that as a possibility. Our beneficiaries with PTSD, those that have served our country faithfully for years, come back and have the wartime memories that haunt them for years. They may not be able to handle their financial affairs. They don't trust their family members to be involved with them. Some are often homeless, so we can work with them in a special needs trust scenario to be able to provide the best quality of life for them. So PTSD is also a diagnosis that can qualify for a trust. You must have a third-party trustee. The beneficiary cannot be the trustee of their special needs trust. You need that person that agrees to hold the assets for the beneficiary's use only. Then we look for an attorney in fact or an advocate. Who can that be? It can be a family member. It can be a conservator or a guardian. It can be the power of attorney. It can be a friend that is well trusted by the beneficiary that sees them routinely on a day-to-day basis. This attorney in fact or advocate is responsible for overseeing the welfare of that beneficiary. It's the day-to-day things that they need. Is there food in the house? Are their utilities paid? Did the bill get to the trust company? Has it been set up appropriately so it can automatically be paid by the trust? Do they have the clothing that they need as seasons change to be sure that the quality of life can be maintained? With these parties together, assets are preserved for special needs, not covered by public benefits. Keep in mind, as we said, with the special needs trust, that the trustee of a pool trust must be a nonprofit organization. So as you, as the attorney, are working with individuals with special needs, if a pool trust is the best thing that you're looking for, search out those nonprofits that are able to be the trustee for this specific trust. A pool trust does have a Medicaid payback and must have that provision in the trust document. That trust document will go over the specific payback and how that is handled at the beneficiary's death. As we move on to our third-party supplemental special needs trust, a third-party trust is created by someone who is contributing the funds to the trust. Funds are generally from a benefactor. They can range from insurance policies. Sometimes real estate's put in trust. Investments can be put in trust. Also, cash assets and resources can be transferred to a trust as gifts to a third-party trust. This type of special needs trust is funded exclusively with assets given by people other than the beneficiary. It is typically designed as part of a donor's estate plan to receive gifts that can help a family member with special needs. It can be while the donor is still living, or it can be initiated at the death of that donor. However, when funded early, family members and friends can also contribute to this trust. They can also put it in their financial planning through their wills that they would like to contribute to the same third-party trust. It can all be referenced in multiple wills to the same third-party trust. They don't individually have to set up one trust for each one of them. It receives those gifts and it helps that family member with special needs continue the quality of life that they've been accustomed to. We'll discuss some of those things coming up that the trust can actually pay for. Upon the beneficiary's death, the person living with a disability, in a third-party trust, the assets in the trust can pass to the donor's other relatives or anyone that was designated within the trust documents. The difference here is that there is no Medicaid payback in a third-party trust. So that situation is alleviated and the balance in the trust has no bearing if the beneficiary has received Medicaid services. The drawback to our third-party trust is that it can only hold funds belonging to the people that have given them to the beneficiary. So the beneficiary's assets, initial assets, cannot go into this trust. So as the attorney and you're talking to people, you may find that a third-party trust needs to be established. And in addition, we may want a pooled trust established at that time. As we look at assets, where can they come from? An inheritance that may not have been properly established in a will, so actual assets are coming straight over. A settlement from a lawsuit. A family member may have been involved in an accident, maybe the beneficiary was. And in order for them not to lose their government benefits, a trust needs to be established. Divorce settlements. The divorce settlement can also not only affect the spouse that might be disabled, but there may be children with disabilities involved in well. So those need to be considered as it goes along. We also have retirement plans. You may get to that age where you have to have that minimum requirement out of an IRA, and you're already on government benefits, don't need that to interrupt those. So you may need to look at the trust there as well. My favorite one is winning the lottery. Bill Emerling, our public relations marketer in West Tennessee, brought this to our attention. He said, hey, winning the lottery is the greatest thing around, and it would be for all of us. But if you're on government benefits already, you stand to lose those benefits and have to reapply when that lottery money may be gone. Now, I don't know about you, but I could probably spend that lottery money pretty fast, and I might need those government benefits back sooner than later. So we need to take a look at that trust for lotto winnings and keep them all safe and sound to use for our special needs. In a first-party trust, a first-party trust is also known as a self-settled trust. It's also called a payback trust. The funds from this trust come from money the beneficiary will soon receive. And those are some of the things that we were talking about. It could be the personal injury, divorce settlement, inheritances, lottery. Those are the things that your first party trust are there and established for. We want to be sure that those funds are put in that trust. There are a few special requirements to a first party trust. You must be under the age of 65 when the trust is being established. A parent, a grandparent, guardian, or courts may establish this type of trust for the beneficiary. With this trust being established, the beneficiary can continue receiving their public benefits, or they can apply for public benefits at that time. Assets in the trust pay for those supplemental needs or services that are not covered by public benefits. And that's one thing that you have to depend on your trust company for, is to be assured that distributions from your trust are not, quote unquote, double dipping in our benefit allotment, because you can certainly quickly lose your government benefits if that's happening. Mandatory Medicaid Payback is a provision that's been in the first party trust since it was established in 1993. Any assets remaining in a first party trust or a pool trust must be notified to the state of Tennessee. Medicaid will look at the money that they have expended, and after the Medicaid payback issues have been resolved, the money will pass according to the trust provisions that were established initially within the trust documents. With a professional trustee, we are often told that a family member feels like they're giving away the help that they want to give their loved one. As we've discussed, the trust company looks for someone to be that advocate or that attorney in fact for the trust. This allows the family member to still stay involved with the day-to-day well-being of the beneficiary. They're able to submit distributions, requesting the payments for services or needs that they had. For larger disbursements from the trust, the attorney, in fact, can work with the trustee to establish a way that those items can be paid for directly from the trust so that resources are not tied up by the family. The wonderful thing with having that professional trustee is that financial records are maintained by the trustee, taking those burdens off the family. You get your K-1s annually from the trust company to submit with your tax information. The trust company will work with you on bills that can be paid that are routine and have them set up where they'll automatically come to the trust. That's less paper in your mailbox, less stress on your table at night when you're trying to sit up for supper and all the bills were placed there. So it's a great way to take some of the financial mundane tasks off the family so that they can spend time staying engaged with their loved ones. They're still involved in the assets. They know what the distributions are, but they're not having to worry about those payments. A trust with a professional, a trustee, allows for these types of financial needs to be streamlined and handled while you have time with your family. Let's take a look at the benefits of a special needs trust. First and foremost, we want to protect personal assets of the individual living with a disability. That's why these were established. We heard the $2,000 spend down for Medicaid. Often we had elderly people that had only saved $10,000 or $15,000 in their life, and their 2 or 3 months stay in the nursing home would put them in poverty. And if they got well enough to be able to go home, all of their savings was virtually eliminated. In addition to protecting those assets, I like to look at a three-way protection that it gives us. Quality of life is maintained. We all know that Medicaid is a bare bones government benefit that we have. Our Social Security disability, those other resources help us, but it's often not enough. It protects those government benefits. If you end up with an inheritance, winning the lottery, you don't have to let go of those government benefits. It also protects a peace of mind for everyone in the family. We often have calls from parents or grandparents. They're concerned. I have a child that has a disability. And I've just now realized with the things that have gone on in these past years of I might not be here forever. And who will take care of my child? Who will be sure he has a place to live? Who will be assured that he can still continue education? This is what your special needs trust can be used for. Another thing that your special needs trust can provide for you is non-medical care services. Often families don't think about this in the many ways it can be used. Parents are still working. They may have a disabled child at home. It may be an adult child that's living at home that you just need a little bit of extra help with. Some of your government benefits will provide a caregiver for you, and you may have that caregiver for 3 or 4 hours a day, but you may need more time than what your government benefits will allot for you. And in that case, you can talk to the trustee of the trust with the non-medical company that you're working with and be able to extend hours over and above what your insurance will pay for. We sometimes get calls from the primary caregiver that just needs respite time. They may be getting sick. They may have things that they need to take care of that they're not able to do while they're managing the day-to-day needs of their loved one with a disability. Their trust company will work with a non-medical company to be assured that the services are appropriate, that the needs of that special needs individual have been properly documented so that we feel like their quality of care can continue while their primary caregiver is away from the home for a little while. Also, if the family is going to take a family vacation, the trust can pay for that beneficiary their portion of the vacation time. In addition, the trust can pay for a caregiver, one caregiver, to go with that person with the disability to be able to help the family enjoy the time that they have together. If the beneficiary requires around the clock care, the trust may determine that more than one caregiver should go on that vacation with them. So that's a great resource that families often don't think about and utilize enough. Home modifications are something that comes up as well. Maybe a ramp is needed. You may need grab bars in bathrooms, bedrooms, playrooms. Depending on whose name the house is in, the trust has to look at that. A ramp may be able to be built, but it may not be able to be permanently attached to the home because the home may not be in the beneficiary's name. That is something that the trust company will work with you as well as the person that you may be getting government benefits from, because there also is a government benefit for home modifications in some of the states, and it is in Tennessee. The last thing that we always like to talk to families about that a trust can cover is pre-need funeral arrangements. We never want to think about our loved one passing away, but we all know as much as birth being a part of life, so is our passing. We want families to consider what they would like as far as funeral arrangements are. Talk about that. They may even be talking about that with their loved one that has a disability. Make those arrangements, get them paid for, get a copy of that to your trust company so that all those things are taken care of, tucked away and out of mind so that quality of life can continue on a day-by-day basis. If you've never used a funeral home, your trust company will recommend for you someone that's close, someone that provides the services that you're looking for. There are other things, the list can go on and on. What I often tell people is if it's not covered by government benefit, if it's legal, you need to talk to your trust and see if it can provide those resources for your loved one. So now, what do you think? A special needs trust may be exactly what your client may need for their loved one. There may be questions that you still have. What scenarios might be there to help us know, to help us think about when you're talking to your clients? At this point in time, I'd like to turn the rest of our presentation over to Darlene Kemp, our Executive Director. She's going to go over some of the ethical considerations that come up as we look at our trust, examples of things that we've seen firsthand, and draw a conclusion to this part of our presentation. Darlene, take it away.
Thank you, Teresa, for that informative session. You have provided us with some interesting information regarding all three types of special needs trusts. Now that we have the basics of special needs trusts, let's move forward into legal and ethical considerations. As an attorney, when considering the use of special needs trusts for your client, there are criteria to consider. In all three types of trusts, the first consideration should be what type of financial device will give the beneficiary, your client, the best manner in which to preserve assets and qualify or maintain benefits. Second, determining if the beneficiary will qualify for a special needs trust is of the utmost importance. Does the beneficiary live with a physical, mental, or intellectual disability? Is the beneficiary a child? Does he or she have special needs? Third, how much money or assets will be deposited into the trust? Will there be future deposits? Fourth, are there items or services that are currently needed? Should those items or services be paid for before the trust is established or after the trust is fully funded? Fifth, who will be named as a remainder beneficiary? In a third-party supplemental needs trust, there is no Medicaid payback after the beneficiary dies. In a first party and a pooled special needs trust, there are Medicaid paybacks. If the beneficiary has many expenses paid through Medicaid over a long period of time, there may not be any remaining money in the trust after the beneficiary dies. Choosing a professional trustee has its benefits over having a family member serve as trustee. There are also drawbacks to using a professional trustee. Which is the best choice for your client? A professional trustee must have excellent communication skills. A beneficiary and the family want to be able to speak with the trustee or a qualified employee and get answers quickly when they contact the trustee's office. Many professional trustees will meet face-to-face with the family and the beneficiary, or now, due to COVID-19, meet through Zoom calls. Being able to see each other deepens the bond between the trustee and the beneficiary. This meeting face-to-face also builds trust. A trustee must follow the law and guidelines related to the type of trust being used. There are times when an individual does not know the law or the guidelines to follow. This could jeopardize the beneficiary's benefits. A professional trustee continues to learn through continuing education. This helps the trustee to keep abreast of any changes in the law and provides the professional trustee with the ability to serve in the best way possible so the beneficiary can live a good quality of life. Teresa has shown us the benefits of special needs trusts with someone living with a disability. It doesn't matter what the disability is, how old the person is, or where their money comes from. There is a special needs trust that will fit their needs and give them the opportunity to live a better quality of life. Now, I will share with all of you some ethical scenarios that will help you to better understand the decisions a trustee must make, usually on a daily basis. These decisions are made to protect the beneficiary's government benefits. They affect the beneficiary's life. Our first scenario occurs quite often. An adult child calls the trustee asking for his or her parents' trust to pay for a vehicle. There are times when the trustee will agree to purchase a vehicle for the beneficiary. However, more often than not, the trustee must say no to the adult child making the request. In this example, the adult son wants his dad to purchase a motorcycle with a sidecar. The son states he will take his dad to all doctor's appointments and drive his dad around with his dog, both sitting in the sidecar. The son wants to keep the motorcycle for his own use when he is not with his father. Unfortunately, this is not an allowable expense. The motorcycle is not for the sole benefit of the beneficiary, and that's the father. This request is rejected, but alternative suggestions are given to the son in ways he can be with his father, help his father, and have fun with his father. The trustee can make arrangements to transport the father to doctor's appointments. Outings for the father can also be scheduled, including the dog. And the son is always welcome to join the father in any doctor visit and outing. Our next scenario deals with a young woman who became paralyzed. She regains her independence, receives a lawsuit settlement, then gets swindled by someone she thought was her friend. Many times, people living with a disability gravitate to a person who shows interest in them. Just think, their whole life was turned upside down. They want to feel normal again. For this young lady, she pushed herself to succeed in reaching her dreams and her goals. She entered the special needs beauty contest. She met people and had lots of social interactions. She was so happy. She was feeling on top of the world. When the photographer approached her, she was flattered. The photographer gained her trust. The young lady shared with him that she had a special needs trust with lots of money in it. The photographer wormed his way into her life and took $20,000 of money that the woman had. What could the trustee managing the woman's trust have done to help protect the woman and her trust money? Sometimes trustees do not pay close attention to where the trust money is being spent. Although paying for a photographer is an allowable expense from the trust, should $20,000 be paid? A trustee can talk with the beneficiary and the photographer. A plan of what the photographer will provide should be developed. An itemized statement should be obtained and reviewed before any contract is signed. The photographer should complete a W-9 tax form. This will give the trustee the ability to provide a 1099 tax form to the photographer to file with his taxes. The trustee can also ask the beneficiary to obtain one or two additional quotes from other photographers as comparison. Then the best suited photographer can be chosen and hired. Remember, the trustee does not want to prohibit the beneficiary from having the photography session. The trustee has a fiduciary responsibility to manage the beneficiary's money in the best manner possible. Here's a similar situation. A beneficiary has hired a personal trainer to get him in shape for an upcoming race. The beneficiary, who was a star athlete, wants to get back into his glory days of competing. The athlete signs paperwork agreeing to have this trainer work one-on-one with him. This was without being quoted a price for the trainer's services. When the final bill is received, the trustee believes the athlete has been swindled by the trainer. In reality, many individual trainers are paid for their training services, and the cost of transportation, lodging, and food when traveling with the athletes are included. Was this athlete swindled? We really do not know. However, if the athlete had talked with the trustee before signing the contract, the trustee could have worked with the athlete to find an approximate fee for all of these services. The cost could have potentially been much less if there had been communication before the beneficiary, who is the athlete, had agreed to pay the trainer's services. You've probably heard of many seniors being taken advantage of by friends. The senior may have no one else to turn to for assistance. He may be willing to give money, food stamps, and personal possessions to have the help he needs. In fact, this does not remain as a sole problem with seniors. Many people that are isolated gravitate to one person that can provide them help they need, and in turn, they give them gifts such as items in their house, even clothing off their back, food stamps, and money to help that friend, so-called friend, return and help them on their daily needs. The friend may not even know the senior is suffering because of the generosity he is giving his friend. Other times, the friend finds the senior has, quote, deep pockets and plans his attack, leaving the senior with little to live on for that month. Well, there are many possibilities. The trustee could arrange for a case manager to visit the man on a regular basis. Now, this only works if the man's trust has sufficient money to pay for the cost of the case manager. Groceries could be ordered and delivered to the man's home. All charges could be paid from the man's trust. Cell phones, internet, and cable service could be paid directly from the trust to the company so the beneficiary's services could remain active. The friend could visit and take the man out, but only as a friend and not be paid for the friendship. The trustee has a fiduciary responsibility to look after the beneficiary, ensure he lives a good quality of life, and protect the beneficiary's assets. My last scenario for you is a true story. The photo in this slide is not of the actual man I speak of in the story. I was giving a presentation at a healthcare facility. During my presentation, a man interrupted me and told this story. He had been given by his father an inheritance of $100,000. He knew that his government benefits he was currently receiving totaled about $85,000 per year. If the man accepted the inheritance, he thought he would lose his government benefits. He would use the $100,000 to pay for his food and clothing and shelter and all of his health-related needs. Then the man knew he'd have a waiting period to qualify for the government benefits he needed. Well, this gentleman talked it over with his caregiver, and he decided to renounce his inheritance. The money was returned to his grandfather's estate. The man asked me if he had established a special needs trust, could he have kept the inheritance and maintained his government benefits? I told him yes, that was what he could have done. He asked me to keep speaking to people about the benefits of special needs trusts. He said people don't know they need a special needs trust until they do. It's been 13 years since I spoke with this man. He made a huge impact on me. You see, to this day, I give presentations on the benefits of special needs trusts for people living with a disability. Each time I do, I think of this man. I hope these presentations can create awareness and help so many. Today, you have heard Attorney Mac Bailey talk about the ABCs of S&Ts. You have heard Teresa Law and me talk about the definitions of special needs trusts and ethical considerations that relate to decisions a trustee must make. What we hope you glean from our presentation is that special needs trusts are not for everyone, but they are for many. A special needs trust can make a difference in a person's life, a person living with a physical, mental, or intellectual disability, a person of any age. Thank you. Our contact information is provided here. If you have any questions after the presentation, please do not hesitate to contact us. And now, please stay tuned for just a minute while we bring Attorney Mac Bailey to join us for a question and answer session. Thank you.